Right, I think it's 3:02. Good time to start. People will continue to join in. Right, good afternoon, everyone. I'm Vijayant Singh, and I'm very, very happy to welcome you to our second session or webinar on the DPDP Act and now and the DPDP rules that now have been released. Like last week's session, this is also going to be an AMA, Ask Me Anything style conversation between myself, Aman, and Sreenidhi, focusing on, similar to last week's session, the more practical, operational, how do we solve this sort of Monday morning questions. We have gathered a lot of questions from the last webinar and even questions this week as well, clustered them into themes, and as I said, structured them in an AMA style where we will work through implementation and practical guidance. And continuing from last week's webinar, today's themes will be SDFs, their classification, what are some of their core operations and obligations. We'll be also looking at legacy data and the transition from older regimes and how you collected consent and provided notices to the new law. We'll examine how you're supposed to process employee data, what are the obligations around that, retention obligations, children's data, parental consent, age verification, exemptions, look at cross-border data transfers as well, and we'll end with what are the obligations around security and breach reporting. Given that this is an AMA style, of course, we have sourced a lot of questions before. Like the last session, it would be great if you continue to, give us some more questions on the chat, and we'll try to take them up in the course of today's discussion. And yeah, on that note, I think we can get right into it. And we'll start with the first theme of the day, which is, of course, significant data fiduciaries, which is essentially the enhanced compliance tier under the DPDP Act and the rules. And Section 10 over there gives the central government the power to notify entities as significant data fiduciaries based on a variety of factors, sensitivity, risk to principles, impact on sovereignty, but we don't have very specific bright line thresholds, not enough guidance over here. So the question that we are receiving, and a lot of organizations have been asking actually over the past couple of years or so, is how is this designation actually going to work in practice? What are the things that we should be aware of right now to understand if we are at risk of falling under this potential designation? What factors should we be considering internally before even any of these notifications start coming out? So yeah, that's the question. And perhaps Sreenidhi, I'll hand over to you to share your initial thoughts, and then Aman, please do come in.
Sure, sure. Hi, everyone. Thanks for joining in. So I think on STS, like Vijayan said, there is a list of criteria that's set out in the Act, which is volume, sensitivity of data, risk to integrity, sovereignty of India, all of those factors, but no real designation yet, no notification yet. I think practically we could take some cue from some. I think one kind of threshold that's likely to come out is user base related threshold. Just because if it's an organization that's processing large volumes of data, you can expect to be designated as an SDF. It'll be so it could be a user based threshold like what we see with significant social media intermediaries in the IL guidelines. I think even the rules, when they speak of data retention timelines, have a certain classification for certain types of entities, which is 50 lakh for gaming companies, 2 crore for social media and e-commerce. So that gives us some insight on user base being a threshold. Of course, that comes with its own set of complexities on whether it's active users, whether it's your entire user base, and what if today you have 49 lakh users and tomorrow you trip a certain threshold. And companies may practically then, I think what will end up happening is if you're in the range, within a certain range, you might as well end up thinking of yourself as an SDF and building in those safeguards, like having the processes in place for data audit, DPIAs, having an officer in place, resident in India as a DPO. And I think so one is user threshold, then also on the kind of data that you're processing, let's say a bank or a financial institution, again large volumes of financial information, financial data, which is Under current SPDI rules, also considered sensitive, certain types of financial information, health as well. So I think those are certain kinds of organizations that are likely to be under the scanner or likely to be part of this sort of SDF classification. I'm wondering, Aman, if you want to add to that.
No, just one. I mean, I'll throw in maybe a little bit more complexity to this, Sreenidhi, and also want to get your views on this. And some of the things that we are starting to hear also is, will this classification be at an entity level? Because if you have multiple lines of businesses, how are you supposed to view yourself, right? Like some may be more user facing, more number of users. Other lines of businesses may not. Uh, and how should you think about it in that case? I mean, plain reading of the law seems to suggest that it's going to be an organizational wide designation. But any tips, tricks on, or do you just make peace with it? Because in terms of obligations, yes, you will have a DPO at an organizational level. Then perhaps, or just any thoughts you might have on this, right? On, I don't know if you want to do a DPI across the board then.
Yeah, yeah. So both I think having an officer in charge might, okay, you can appoint a DPO and they can serve as the DPO, but even that might not work if you have very distinct product lines and actually you want to appoint a DPO who is well entrenched in that sort of platform and product line. So there may be some complexity even there. But yeah, it is a tricky piece. I hear you when you say that at least the letter of the law suggests that it's an entity based classification, and that's that. But that might throw up a lot of concerns for companies. This is not a theme that we've heard a lot of people also talk about. Interestingly, like although I think it does throw open a lot of practical challenges. You may have a SaaS business line, you may have multiple business lines which are where one particular one where let's say you only have a lakh users, but other platforms and other business lines which are much wider and much more sensitive data that you're processing. But that would mean you're effectively applying the same standard across the board. I think where it is possible to have very clean demarcations between product lines and these operate entirely as distinct units within a larger company, you could still make a stronger argument that it is a particular product or a business line which is STF. I'm not saying that that is necessarily supported by a strict reading of the law, because it just says company fiduciary or class of fiduciary is designated as an STF, but that makes most sense to me. That sounds more reasonable, where you can actively clearly demarcate products. But if there is any mingling of products, users, services, it might be harder to say no, this one is insulated entirely. Maybe in the future we'll also see if there are such distinct product lines, they get hived off, they are housed within different corporate entities. That is of course challenging from a revenue perspective, investment perspective, but that may be something one has to do to insulate certain product lines from the higher requirements for SDFs.
Got it. And I just want to build on that principle of abstracting the product line question to different sectors and different businesses. And, we get this question a bit from especially certain businesses that may not think of themselves as sensitive or significant, and you take, for example, agriculture, logistics, B2B services, they might be handling a lot of data, but maybe it's not sensitive data in certain circumstances. And for companies in these sort of less obviously sensitive sectors, what's the risk over there? And then to sort of flip this question again towards, let's say, fintech or banking, is it something, should the risk of SDF classification be considered imminent or almost automatic for those sectors?
Mhm. I wouldn't say automatic, but there is a risk just given the nature of data that they process, especially financial services institutions, large banks, NBFCs, just both in terms of volume of data and also in terms of the kind of information that you have, especially for businesses like lending, payments. There is a huge volume of data that you're generating. So I do think a little more likely to trigger whatever classification comes in. For other services like agriculture, allied services, first fall point of point of course is there has to be personal data. If it is non personal, if it is completely soil patterns, that kind of data is outside the scope of the law entirely. But otherwise, if you whatever notification comes in, if it's a user base threshold, then it doesn't matter whether it's sensitive or not sensitive, the data. If it says personal data records of such and such number of users, then it wouldn't matter whether it is agricultural data or if it is financial or health information. I think this was when we were discussing this question earlier, which and you'd made a point about even agricultural data may have some sensitivity involved. Let's say credit information of farmers and other folks. So just because it is not traditionally seen as sensitive would not mean that you are not at risk of SDF classification. Feel free to add to this.
I mean, Sreenidhi, would it be fair to say that despite the rules coming out, this is that one area where till there is more notifications, we are still operating a little bit in that dark. But also from a preparation perspective, like what do you think there will be some organizations which will have a gut check
Yeah.
sense that you are, and I guess it's the ones which are a little bit on the edge, which can maybe take a little longer. But any thoughts on just on that aspect as well, right?
Yeah, I think there's one class of organizations that will know that we are going to be STF, large volumes of data, large user base, very, very sensitive. And when I say sensitive, very commonly understood perhaps as data that can invite more trouble if breached. But yeah, there is that middle layer where you're closer to the edge. You might, so it's a question of actually building that hygiene, building those foundational blocks to be able to, even if you become an SDF at any point, you have enough of a foundation to then bridge that gap. So for even a data audit or a DPI, the basis for doing
Yes.
those is your data mapping and your basic impact assessments. In fact, DPIs for certain processes you may want to do as a organizational and technical measure in any case. So just having those foundations in place is actually desirable for all organizations, but particularly those in that middle layer of not sure if we'll end up being STFs, but not entirely out of the woods either.
I think that's fair.
Yeah, no, exactly. And I think it must be said that, especially for organizations of a particular scale and already those running mature governance programs for several years, I think a lot of these obligations will not be alien. DPIA's audit, of course, having a DPO. Of course, there's a question on frequency and then a question on, how you really assess the algorithmic risk requirement. But yeah, on that note, also perhaps want to move on to some of the at least one theme which I think is quite practically pressing, which is focusing on how organizations will process or change their processes around using legacy data. Of course, most organizations, most businesses will have years of personal data collected under the old regime, the IT Act, SPDI rules, obtaining consent, through whatever mechanisms existing at the time. The fear and some of the questions reflect that is this new law, the rules is now going to require a mass reconsenting exercise, potentially going back to every single user, getting a fresh consent, meeting the requirements of the law. Sreenidhi, what's the actual position of the law here?
Yeah. So I think this is a provision that as a not very layperson user, I'm excited about. I'm excited to see where all my data resides across different platforms and company. But yeah, I think what the law requires you to do is not fresh consent, but if you have already taken consent in the past for processing, once the law kicks in, you must issue a fresh notice to individuals. So even if it is not taking fresh consent, it does mean sending out notices to individuals, informing them that hey, your data is with me, which allows the user to then object to it and say don't continue to retain. But yeah, it is not fresh consent. Having said that, there may still be instances where you may be better off taking that consent. Let's say it's an active user base that you have, and your users are. I know Aman has some thoughts on it, so I'll let him come in also. But for an active user base, you may actually be better off taking fresh consent with your fresh privacy notice. Or if it's a completely distinct, unrelated new product, or you're cross-selling this data for something else, it was not envisaged earlier at all. It's more than just retention and continued processing for the purpose for which the individual originally gave their data for, then you may be better off taking that fresh consent. But yeah, Aman, I know you had some thoughts on how apps could do this.
Yeah, I mean, just thinking through this a little bit practically, right? Like one thing you spoke about, Sreenidhi, was you're looking forward to getting a bunch of those emails saying we have your data because at some point you've consented to this. But just kind of thinking this through practically, what might be a better means of doing this, right? Like if you have like you were saying, if you have an active, engaged kind of user base on a app that you provide, would it be a more natural place to do a pop-up notification there and just use that as an opportunity to get fresh consent rather than relying on this? Because I know we're reading this provision in a way to make it such that it isn't redundant, right? Because one extreme view could be that the consent you collected earlier also needs to meet the standard of consent under DPDP, which I don't know anyone wants to do that exercise either. So, I mean, if you're ever pushed in that direction, wouldn't it could make sense in many instances to just um, do this as a fresh consent collection exercise, even with your existing users, as maybe an additional, as a, yeah, just to be err on the side of caution almost, right? Oh yeah, and I just saw a message on the chat. Like I think something we forgot to say in the beginning, but as we are going along, we'd love for people in on this conversation to also keep sending in questions, comments, as we're having this discussion. This is not meant to be just us talking at you. So feel free to throw stuff our way. But I'll pause. SS, if you wanted to respond to that as well.
Yeah. I think that works like an in-app notification, or like you were saying, you log out users and make them kind of come back in
Back
with that
in.
with that fresh notice. That works for that active user base, but it may not help you completely meet your obligation under the law, because there may be a significant percentage of users that are not active users and that don't necessarily have your app and are using it day in day out. So it works well as an additional layer, but I'm not sure if it can work standalone, because there is still a significant user base that you might have, which is logging in, or actually, which needs to be notified. At least that notice has to go to them, which may never log in for a year or so, but you need to meet your obligation under the law for sending them that fresh notice.
And that fresh notice will be an email, or would it be something else, right? Like, because in certain places the law does talk about how that
User account.
mechanism, yeah.
User account. So any profile, any account, it could be a phone number linked, email address, whatever the user has used to register on the platform. I think that's how you notify people about breaches and other pieces that are mentioned in the rules. So perhaps that's what you then use to notify users, whatever information you have on file about them. You use that to communicate with them.
And maybe I know
Yeah,
we're
I
going.
think one other question that we often get here is, what if it's a public notice? We put it up on our website. Would that work? I'm not sure if that would work and that would help us. That may work additionally, a website pop-up. And this is often when you're logging in, there is a banner that you see saying we're updating our terms and privacy policy. So that notice, definitely, I think that's a great way. It's similar to your app signing out and signing in, but that works very well for existing active users, may not be enough to reach your entire database.
Hmm. And just one follow-up over here, Srinidhi and Aman. I know parental consent and children's data is a whole piece that we're going to discuss. But how does this play out in the context of parental consent, right? Especially the linkage of 5.2, which allows the transition and continuity of old consents, whether that extends firstly to the parental consent requirement, and especially in a context where you might have a business that believes at least that it's taken fairly robust consents from the parents in the past.
Yeah. So if it is a platform that actually had some great parental consent methods, and if they're not really updating them, if it's the same, let's say you were already doing some massive, extensive verification or something of the sort, then maybe you'll be able to justify it because it's still the parent you're communicating with. You know who the parent is, and you issue them a notice saying, I have your child's data. But if earlier you had no method, no way really of I mean, you were not required to, and hence you didn't do that, due diligence for making sure your parental consent methods are robust. Then again, I think you may be better off taking fresh consent there for children.
Got it. Moving on now to, I think this topic comes up almost, almost every single conversation with businesses, clients. I think it's relating to employment. There are questions around, of course, the legitimate use of processing data without consent under the under 7.1, but also whether in certain circumstances will consent be appropriate? What are those circumstances? Broadly, what is the right framework for approaching how to process employees' data under the Act? Of course, we have 7.1, which covers the legitimate use for employment purposes. And it has, elements like safeguarding the employer, preventing loss and liability to the employer, protection of trade secrets, confidentiality, and so on. And what would then be other circumstances which might not be covered by 7I and then would require a specific consent from the employee?
Mm. Sure, yeah. I think for employment, like for any other business line, product, consumers, anything, even for employee data, an organization would have to do a data mapping, identify why you're collecting data of employees for what purpose, from uh, recruitment to kind of, termination, and even then on, even past employees' data is retained on file for various purposes. So I think um, practically the step remains the same, that you do a data mapping and you identify what is it the data is collected for and used for. Then you identify what all can be justified under that employment purpose legitimate use, which says that you can, all of the things you listed, safeguarding the employer, protection of IP, trade secrets. I think routine processing activities like payroll and compliance, and some security measures as well, even some level of employee monitoring, attendance, like a lot of this is in that umbrella bucket of classic employment purposes. But I don't also read that as a carte blanche to process any and all employee data. Let's say you may be running some survey or a diversity initiative, or I think there will be enough examples of data being collected of employees. Let's say you run a survey on burnout, and this we've heard from folks that there are, and you fill in a lot of information. There are questionnaires circulated. People are asked to put in their thoughts, comments, sign with their names. I'm not entirely sure if something like that can also be justified under employment purpose. You may still want to make that argument, but you'll have to justify that. Well, that's a core employment purpose. So we'd run like these series of workshops, and I think one of our case studies was you do a DPI on a on an employee software which is monitoring the health of an employee, seeing, giving you risk indicators of, hey, this person is close to a burnout. Like, that was a very egregious kind of an example, and it really made some people uncomfortable. But yeah, if something of that sort is what you're planning, it may not be justifiable under employment purpose. But let's say it's a factory and it needs to collect data about someone's health parameters and it's required under law, that would be fair. That would be an employment purpose. So I think for each organization also it might look different. What exactly is it that you're doing? Some close surveillance monitoring may be appropriate in certain kinds of security settings, but may not necessarily work for a random shop. So I think it would also be very, very context specific. But yeah, I think routine processing justify under employment purpose, but have a basis for that. But other stuff, then you'd end up having to take consent. I know Aman has some strong views on employees and consent, whether consent will ever be able to meet the threshold. An employee's consent will ever be able to meet the threshold. I'm wondering, Aman, if you want to come in there.
Yeah, I mean, that's just coming from a place where other laws like the GDPR kind of make it pretty clear that in an employment circumstance, consent cannot be a legal basis for processing because consent cannot be freely given. And I mean, just to what you were saying, right? There a lot of the processing of employee data could very often be justified under this broad purpose of employment purposes and those ancillary things, but there will also, and for everything else you suggested consent, but I think that still compels us to do that evaluation of or at least create that feeling that withdrawing or not giving consent in that circumstance does not have any negative implication on you, because that's really the place where other regulations have come to say consent cannot be the basis because it can't be freely given in a lot of employment contexts. And I guess the effort will then be on how do you justify or make a strong case for saying, no, it was actually still the circumstance of this collection, while they might be this might be collection from my employees, but it was, a situation which would not in any way negatively impact them. I mean, just a random example could be you're running a blood donation camp, and as a result of which you're doing this, and people are voluntarily providing information for, and your non-participation in that can't be viewed as can't be viewed negatively against you, right? And I mean, those will be, I think, some of those tricky places where the one thing I think companies will need to do is kind of think hard about it, right? Like go back to that original mapping of what you're doing, why, and all of that. But I don't know if I mean, you have thoughts which differ, Vijayant, Sreenidhi, on this, or do is there any chance that a regulator would come and say in no circumstance an employee can give consent also, like that kind of almost extreme view, right?
I don't think that a regulator could say, like in India, under India's law, that would be a fair reading, because that would mean that all data processing has to be justified somehow under employment purpose. Which I mean, I think then if we were to say consent can never be used in an employment context, and if you want to process some data about employees, then it all has to be under that employment purpose. It would mean that if you're running a blood donation camp, you actually cannot collect any data about or you can't do that activity that you're hoping to do, because I don't see what other window there is, or leeway there is in the law to do it. But I hear you on everything. There are many aspects of employment that will get covered under employment purpose, and whatever aspects are not, those, when we rely on consent, it has to be a true choice, otherwise it would be employment purpose. So if it is a condition of employment, then there is a different kind of a threshold for it. But if you're saying consent, I do agree with you that there has to be some indication and some effort that you also make as an organization to show that there was choice here.
Yeah, and I want to just perhaps see how this plays out in practice. And we've got a question on alluding to a very specific scenario, so which is biometric information, how fingerprints, facial recognition might be used by an employer for attendance, access control, all those purposes, and fairly common practice. But biometric data, of course, there is an inherent sensitivity to it, even though the Act doesn't formally recognize it as such. And in terms of the questions, I think 2-3 parts over there, try to break that down. First, whether biometric collection of, for these purposes, attendance, access control, security, what's the appropriate ground you might want to go through? Is it consent, or will that be covered under, legitimate use for employment? The second question here is for employees whose biometrics was already collected under or before the DPDP Act, would you need a reconsent? And then the third, alluding to just retention, especially in the context of employees who are not employees anymore and have moved on from the organization.
Yeah, I think the question of biometrics, even a lot of the European regulators have been divided on. But I think the more appropriate legal basis for something like, I mean, if you're collecting biometrics for attendance and security, it seems more attuned to employment purpose. There is a reason and a rationale connected to employment for which you've instituted this safeguard. Anyone coming in and out, you want to make sure when people are coming in, when they're going out, and so on, and even attendance generally, because I also think I'm not sure how meaningful consent would be, whether you would ever be able to show that consent was not voluntary in this scenario, and it is like some essential employment purpose that you're trying to fulfill, which is security and whoever's coming in and out. Having said that, I think at the same time there would have to be some controls, at least information being given to employees as to, well, we do collect biometrics, this is why, what it's really used for, not use or share it with any other external entity, even internally. Limited access controls, security. If you're getting a third party vendor, do your due diligence on who that vendor is, because you're not really giving the user or the individual a choice here. It's kind of a condition for employment. So I think all of those things you'd still have to do, that you have some safeguards around the use of biometrics. And yeah, I think same for any other actually data point. Biometrics is, of course, there's some sensitivity associated inherently with the nature of the information, fingerprints and all of that. But any other data, I think you'd still need to make sure that all of this is complied with. That if it's a third party HRMS software, you've done some diligence around whether they've faced any data breaches in the past, because if you're processing payrolls through that, then so you do all of that assessment. I think what I'm trying to say also is that I've often heard it said that employment is an exception, but it's not. It's one of the legal basis for processing. Everything else to do with data processing, data protection, you do have to comply with, even for employees.
Understood. And just to further elaborate why, this legal basis question, consent or employment, again, might be more important in practical terms. One question, as you can see, it says, what if an employee comes to HR, says, I withdraw my consent for processing my bank account details? Of course, you need that in order for payroll and paying salary. How should a company respond to such a request?
So I think consent is not the right basis in those circumstances. Bank account and essential employment functions. That's why we have the legitimate use for employment. So even in your internal records, you recognize that consent is not the right basis. It is employment. You may still have provided individuals information, and I think a notice is important and essential, telling employees that this is all the data that we have and this is what we use it for. But it's not consent. It's essentially it's a condition for employment, almost, that this is part of. That's why that legitimate use has been brought in.
Got it. Before moving on to data retention, which is the next theme, I think there's a couple of questions that have popped up in the chat. Happy to ask those to you, Sreenidhi and Aman, and maybe we'll take one of them right now and then revisit the other a bit later. So the question is, in terms of insolvency, when a company is winding up, will personal data of its clients, for example, if an e-commerce platform was winding up, could the personal data of its customers be considered an asset of the company, since, of course, the company spends money maintaining that for analysis and so on? And can that be sold to other companies while being compliant with the DPDP Act during insolvency procedures?
I mean, there's some exemption under 17 F, if I'm not wrong, right, which talks about if the processing is necessary for an amalgamation, restructuring, otherwise. But I'm
it's
wondering
a court approved one. Yeah.
Yeah, if that would apply to a, I mean, I think we'll have to evaluate. I think the basis will either come from some of the exemptions there, or how you plan on kind of running the business. If the business is going to be continuing, then the change of ownership doesn't necessarily make that difference, right? As long as the processing activities, and your ability to enforce your rights, etc., remains unchanged, I think should be doable. It's hard to answer this like in a little bit of abstraction. So there could be ways of doing it, but to break up assets in terms of just data and selling that off, I think that might be a little trickier to. I don't know if you think otherwise, SS.
Mhm. No, I think that's fair. While the law doesn't say anything about sale of data as such, it doesn't say you can't monetize, can't sell. But I think one would have to see where exactly is this transfer falling under, whether it's um under an exception. If it's not, then if it's with consent, then it has to meet all of the threshold for consent as well. But yeah, nothing more to add.
Yeah, and before we maybe move to retention, we also have one kind of question which often comes up in the context of employment, is prospective employees, right? Like if I'm applying for a job, or if you've gotten candidates who are interested in working with an organization, and as a result of which you end up processing their data, or like retain their interest. You keep a file of people you might not have hired but want to at some point. um, would you justify that as and especially if it's not an inbound application, right, where you could argue it's like voluntary provision or whatever, but where you put out a call for applications, and applications start coming in, how does that look? Would you justify it as consent, employment? Where do you put that?
Yeah, I think practically when you're soliciting applications and someone sending in their data, you actually you inform them that this is how we'll be collecting and retaining it for such and such time. We actually keep candidates' data on file. We run background checks, and we use third parties for it. And after having seen that as well, the candidate continues to engage with you, and provides their acceptance or consent or whatever we might want to call it. I think practically that's what you do: put out enough information and tell them exactly this is what you're doing at the recruitment stage. And yeah, essentially then use that notice and their subsequent confirmation or acknowledgement of that and provision of data to you, to process it in that way. On whether specifically it is, I've heard kind of both interpretations. I think there is one line of argument that while that this is kind of a condition for employment, background verification is for safeguarding employers from loss or liability, or all of the factors that are laid out in employment purpose. So you could potentially think of whether, to what extent can that be used for something like running BGVs. But otherwise, even if we were to fall back, I don't mean to say fall back, but even if we were to rely on consent, then it would mean a clear notice to the individual, and despite that, they engage with you, because there they do have a choice of saying, no, I don't want BGV. It's fair for the employer to say, well, then we can't hire you. It's a condition for our employment. But yeah, there is that choice that the user has, which they may not have in other employment contexts.
Right. Right. Moving on now, I think also mindful of time, and definitely do want to get to some of the children's data pieces today. Touching upon data retention, retention under the Act and the rules is, I think, where you're given a principle in terms of how to go about it, but also a number. Obviously, Section 8.7 says, do not retain data or erase data when the purpose is served, or when consent is withdrawn. You now have the third schedule that prescribes specific timelines for social media, gaming, e-commerce, 3 years from last contact. And now there's 8.3 as well, which gives you a floor of 1 year minimum retention for all data fiduciaries. But beyond that, beyond A3 and everything that applies to these specific classes under the third schedule. For other data fiduciaries, what's really the practical approach for determining, how they should retain data, for how long they should retain data, how should they build internal retention schedules, especially in contexts where the law might not give you a timeline.
Yeah. Aman, do you want to come in on that one?
Um,
Retention. Yeah.
I mean, one is the I guess there'll be a few different ways of making that determination on why you'd end up retaining employee data, right? Like, not just employee data, sorry, but there could be other legal requirements which require you to retain data. Companies Act, tax. There could be many grounds. I think one thing that I very often talk about is just limitation, right? If you're a consumer facing business, you might want to retain records of transactions with your consumers for a longer period because you're anticipating that at some point there is litigation on any of that. So just the period of limitation very often at least 3 years. But how you do that also then becomes, I guess, important, right? Like you just archive it and you're only retaining it for that limited purpose, but you stop actively processing it. But and what I mean, Srinidhi, I'd also love to hear from you on what a general good, what would be an easy to justify retention period for most businesses. Do you benchmark to what's already been given to us in third schedule, and you kind of extrapolate that out for pretty much all other kinds of businesses, or do you do a more kind of evaluation basis? What seems like a reasonable retention period for the specific industry that you're in?
Yeah. I think firstly, you look at things like your Companies Act and tax records. So anything that has some financial involvement. I don't, I've just,
Yeah.
word is eluding me, but yeah, if there is any kind of connection with, let's say, invoices or any other such information, you might want to hold on to them for longer, because tax notices can come even many years after you filed your assessments. 10 years, I believe, was the timeline. So even 8 to 10 year timelines for that category or class of data that's relevant from a taxation perspective or companies. And there's mingled data, there's some personal data, and there is a lot of business data as well. But I think for other consumer contexts, maybe something like a I mean, I'm looking at the 3 year timeline, which the rules have anyway specified for certain classes of data fiduciaries, 3 years from user inactivity. And I think and that's the timeline in the Limitation Act as well for a lot of claims, and consumer or disputes as well. So that might be a reasonable time period to look at if there is no other law requiring and justifying longer retention. Yeah, so 3 years from user inactivity. But I'd also not think of it as retain that entire consumer or employee file or delete the whole of that. I think there are pockets of data, of course, that require some engineering, which means some costs, but even continued retention involves costs. So if within a file there are some parts of the data which you absolutely need to hold on to, you hold on to them for longer, but there may be some that you don't need. Which is, anyway, I think companies are also increasingly becoming aware that they might not want to have large pools of data with them, that increases their risk exposure as well. So I think just factoring that in, also in this conversation.
And Srinidhi, I don't know if you've seen on chat, Bobby has asked us a very specific question around telecom companies thinking about retention of subscriber info. Um, I don't know if you have any immediate thoughts
Yeah,
on
no,
that.
this is a query that we get often. I think not just from telcos, but otherwise, can you use LEA? Can that be used as a means to, continue to retain subscriber info or other data? The law prescribes a minimum 1 year timeline. Then just this data protection rules across the board. But think I do think companies hold on to data for much longer. Maybe a good point of reference would be even looking at older LEA requests as to how far long have they sort of dated back to. and make some kind of a practical assessment of what would be a reasonable time frame. Of course, the limitation consideration doesn't apply here, especially if it's in criminal investigation or something where law enforcement agency comes knocking to you. But if there is no requirement to retain,
Yeah.
and the law enforcement agency asks you for that data and you don't have it because your data retention you remove the data, I don't think there is you're not in a you're not non-compliant with any law as
Yeah.
such. But of course, every sector, depending on how often you're getting these requests, you may actually want to hold on to that data for slightly longer to be able to be able to respond. But it isn't required as such under law. Where it is required, the law should specify. That's why there are, under PMLA, there are guidelines as to how long you hold on to uh, transaction records and KYC data. So ideally, the law should specify, but if it doesn't, then perhaps this is a way. And I also think one thing to just bear in mind is, if we are retaining that data for potential investigations and such lawful purposes, we should make sure that it's not used for other purposes. Once whatever timeline we have, like, we shouldn't necessarily then use subscriber info for, let's say, marketing or other purposes, but we only archive it for certain lawful purposes.
Thanks, Srinidhi. One last question of retention, and I think relating to children's data, and that also allows us to segue into the children's data segment, perhaps one of the area of the act and the rules which have created the most almost operational questions a lot, or at least one of the areas where we've got a lot of questions. But just on retention and children's data, anything specific over there, any specific considerations that businesses or organizations should consider when deciding retention timelines? I think there's also been a question on whether a specific consent would be required for retention, or if the original consent for processing covers that.
Mm. So no, nothing specifically for retention. I'm assuming that this question is just about like about retention and not about that legacy data. If you have legacy data, then I think we covered that
Yeah, we
earlier.
covered that.
But yeah, nothing specific about retention. But like we all know, I think for all processing we need parental consent, which is verifiable, and that would include retention as well. And I think retention deletion will be handled for children, will be handled similarly to adults. Maybe there is an argument to be made that given the sensitivity of the community, you may want to think about how long you're holding on to the data. From a business perspective, it's also how relevant is that data. But yeah, I don't think there's anything unique here, unless Aman, do you have any thoughts on that one?
Okay.
No, let's move to everyone's favorite.
Business
Yeah,
data,
yeah,
yeah.
the showstopper. So Rule 10 says you have to verify, of course, when you're obtaining the verifiable parental consent, you must also verify that the person giving consent is an identifiable adult. The question that we have got is whether you also need to assess whether they are actually the parent of that child.
Hmm. So I think the rules fall short of saying that. They don't necessarily ask you to establish the parent-child relationship, and I think the reason for that is also it's pretty hard to do that. I don't know if there is a good way of actually establishing parent-child relationship. Even with government IDs, that may not be possible, and I don't think that that's the expectation. We've seen this phrase verifiable parental consent even in the US COPA and FTC guidance around it. It all I think there is, as such, the rules don't go to that extent just yet, but you do of course have to take parental consent still and verify that that person is an adult.
And on this verification that this person is an adult, and the pathways that the rules give us, 10(1)(b) obviously talks about identity details, issued by government entities. Is this limited to DigiLocker, or can organizations use other authenticators like eKYC, VCIP? I think there's a couple of those mentioned in the question.
Yeah, amazing. Yeah, I think there's nothing requiring a platform or a company to just use DigiLocker or other notified services. They've not made it overly prescriptive. They've have left it open to companies to determine how you make sure that those details of age and identity are obtained by you. So it's not overly prescriptive or limited to a certain set of services in that sense. So I think it's up to the platform to decide whether we want to engage the services of a third party or whether we want to implement and run this ourselves in any way. Yeah, essentially, there's no requirement to limit to DigiLocker. And also, I don't think that infra is built out even within DigiLocker just yet. But yeah, I think we'll gradually see more services also developing for this verification.
Aman, did you have a thought here?
No, I don't think much to add there. I think what Sreenidhi said, right? Like I don't think there's a bar. It'll that evaluation of whether you want to do it yourself or choose a service provider will be very much a pro con kind of analysis as well, right? Because any or how much assurance you're getting from the service provider, either in terms of indemnification or otherwise, because the risks of non-compliance are also pretty severe. So just that addition, I don't see a bar, but that the little bit of that the evaluation will certainly be something you need to do.
Got it. Got it. I want to talk about what verifiable consent means in practice. What would qualify as verifiable parental consent? If you're building a, website flow, what would consent look like actually? What are the specific elements that would be required? Of course, the rules and the law gives you some level of freedom to design this, but are there any practical considerations we can give to businesses, organizations?
Yeah. Yeah, I think so. There are various ways for verifiable parental consent. I think from just I mean for taking such consent, which is like areas which could be from just saying enter parents' email ID and doing some kind of an email authentication to something way more stringent, which is asking for government IDs and then at the back end running some check to make sure that it's actually legit and so on. So there is a spectrum. I think around the world we've seen a lot of these measures evolve and develop, from OTPs to IVR calling to having a quick video check, maybe even AI based checks for whether this is um, an adult that we're actually interacting with. I think it's a pretty tricky piece as to what would constitute verifiability, especially given the nature of your service or your platform. Whether it is actually a strict standard for KYC or it's a much lower kind of a threshold for just some OTP verification or an email verification, and each platform will have to decide what that assessment or what that due diligence kind of measure looks like for them. I think if it's a I don't know if you guys have thoughts or want to come in here. I know when we were speaking about this, we thought about, we explored what this might look for gaming platforms, what it might look for dating apps, and others educational platforms themselves. So yeah, please feel free to jump in.
Vijay, you had some thoughts. Why don't you come in? You've only been asking us questions so far. We want to hear from you on the
No,
toughest
I think
questions
I
there
think
are.
no, of course, and I think this kind of relates to the next very difficult question I was going to ask you on the question of age gating in particular. And I think generally the question over there, of course, which we might get to, or I might answer right now myself, is whether there's a universal requirement over there. And the thought, at least personally for me, is that there isn't, but you would need to make that assessment on a case by case basis. So whether you are a platform that's targeted towards children, but let's say lesser risk, what parental consent might look like, and the individual steps which would start from age gating, moving on to then identifying the adult, and then of course getting that affirmative consent might look a little bit different. Or let's say you're a product or a platform that's not targeted at children, not something that is an IT SaaS company where you can't imagine children genuinely going on the platform, then that might look quite different. Age gating might not necessarily be the biggest concern you have. But of course, if you are a platform where you would ordinarily imagine children to be there and there's a significant risk, and I'm talking about gaming companies where some level of money is involved, then of course, I think generally the expectation would be that any age gating and that entire consent flow that you're imagining should be of a particular robustness. And again, what that might look like is lots of options over there. But yeah, my thought is that has to be risk based. Some of the methods of age gating that we're seeing, KYC is obviously over there. Assessing whether the adult is an adult or a child is a child. There are certain complex puzzles that we see certain platforms also give. So there's a variety of options over there. The choice that you make depends on the profile and, of course, the mechanics of your platform, and then how much you're willing to invest in that. Aman, over to you.
Yeah, no, I mean, I tend to agree. I think I don't think we could, and yes, this was an worry. I think when the law was being drafted, that does this create a universal age gating kind of obligation, or what does that standard that you're going to apply for the age gating? And I don't think that could have been the intent of the law, but one will have to take kind of a rational, risk based view on this, right? Like you'll have to and one way of doing it is, even today, can you, looking at your general user base, what is how many of those are those below the age of 18, right? I think that's the one distinction that's come in as a result of this law, is that you might have a lot of users in that closer to adulthood rather than absolute minors, but still the law will now compel you to bring in some kind of parental consent in that situation. But existing data could be that basis, or if you're starting a new business, then look at how similarly placed businesses are doing this. I think those are good kind of starting points for that risk evaluation as well, right?
Sreenidhi, anything to add on over here?
No. I think nothing else to add. Risk based and a lot of the stuff that we were speaking of. There was, I think, one question also on. I think just this one on, will individuals be required to give their age across all platforms? I don't think so. I don't think the expectation is that each platform will ask individuals to say what their age is and then only proceed. But maybe there is a self declaration or something. But yeah, I think those changes we'll start to see. And there was another question on exceptions earlier, I believe, on just consent, and I think those are the exceptions that are laid out in the rules themselves, on if it's an educational institution, healthcare institution, there are some exceptions laid out to verifiable parental consent. Those are, of course, narrowly tailored to specific circumstances.
Understood. I'm also mindful of time, and we do have a couple of themes to cover. And perhaps what I'll do is I'll throw a question to both of you on each one of them. Cross-border data transfer is one, and the other security safeguards and breaches. Maybe starting with cross-border data transfers, I think the law is clear on it, but of course there's still a lot of conversation and understandable questions and confusion. So what is the current state of play under the Act now? What do the rules say? And how might organizations prepare for what the rules say?
Yeah, I think the law is pretty silent on restrictions or anything of the sort on cross-border data transfers, except those two, except just saying that it will come up with notifications for what countries you can't transfer data to, and those provisions in the rules which say for SDFs we could ask them to localize certain data and also add some restrictions on how foreign governments can access data. I think just kind of keeping close track of what are the notifications that the government comes out with under this. And I think for any transfer, whether it's within India or outside, there will be some similar safeguards that one has to implement. In the absence of a blacklist or a list of countries, I think that's all that I can say right now, that any transfer that you're doing, if it's outside India, I think you might still be better placed in doing some risk assessment, practically on where is it, what is perhaps also the likelihood of that country being on a blacklist. I think just a little bit of that assessment, because it can be a huge investment to then migrate your data from a vendor somewhere located in a dicey location or a risky location to back to India or elsewhere. So I think operationally you might want to just keep an eye out for what those um, countries might look like.
Just one follow-up over there. Of course, there's 12 speaks about a committee that will uh, identify categories of data to be localized or not transferred outside India. I know this is a bit of crystal ball gazing, but any idea what those categories might look like?
For SDFs to localize certain types of data. So I'm thinking of when one of the earlier versions of the law had talked about critical personal data, where it was certain types of data which may be sensitive from a national security perspective, or useful for investigations, perhaps. So maybe that is the line, but even there, it's there isn't enough information. Right now for us, either on that committee or on the categories of data in the act or the rules to say. But if I were to hazard a guess, it's data that's sensitive from that perspective.
And Srinidhi, do you think, I mean, while all of this is on the books, the requirement is likely to still continue to come from your sectoral regulators, right?
Mhm.
Like RBI, etc., who've
Yeah.
already done this for payments data.
Yeah, that also. I think already there are, I think during these consultations also there were indications that this is for justifying or for us to at least be able to have that enabling some backing so that there's consistency among what different regulators are doing. That let's say RBI says store payments data in India, it's important from a supervisory perspective that you could potentially do that. Having said that, I don't necessarily like that's not the only way either. For like the RBI could still come
Yeah.
out with notifications itself and say, no, this category of data is essential for me. And the law also provides that leeway, saying if there is a sectoral law that provides a higher threshold, then we
Yeah.
sort of abide by that.
Great. Last couple of questions on security safeguards and breach. I think on security safeguards, we have Rule 6 that sets out at a minimum certain safeguards like encryption, access control, you have to maintain logs for a year, backups, continuity measures, and so on. How should organizations, depending on, of course, their context, the level of scale, the sector that they are in, understand what at a minimum means and then deploy that into practice?
Mm. Mm. I think also depends on, let's say you already implement the ISO 27001 standard. I think a lot of this would be taken care of. So there may be multiple levers. There is the people layer, there's processes, there are technical measures, there is governance within an organization. So across each of these, some standards that you have as to within each of your databases or within each of your applications, there is some network, there's some security firewalls. There is also some level of encryption on how you're engaging, how you're accessing, downloading data, access controls. So all of these are themes. Third party risk assessment is a big theme, which is also recognized within the security safeguards list of 6 minimum guidances, that everything here you must also make sure your third party vendor is doing. So I think all of these themes across, the four five bullets, your existing infosec processes, you'd look at, and you might actually be doing a lot of this already. But if not, at least base level assessment of what is needed here. But people training, sensitization, having processes, having a governance structure, having even a person in charge for these pieces, then whatever technical measures that you need to implement.
Just one follow-up over there, especially when the draft was released, a lot of the concerns were that, we talk about security and all these practices should be risk-based, could be contextual. Uh, a lot of the concern at the time was that this seems to be a little bit prescriptive. Are you reading that prescription into this, into how this particular rule is designed, or do you think there's enough leeway here for, let's say, a startup to figure out what processes work for them versus a company of a much higher scale?
Yeah. So I think across each of those 6, 7 requirements that are listed, there are words like appropriate and reasonable, which do allow us to think of exactly what our business is, what is the kind of data that we process, and what would be appropriate given that context. So yeah, I'm inclined to read it more positively, to say that, well, it is essentially saying you decide what are appropriate measures, you decide what is a reasonable measure. I think each of those has those phrases, but yeah, of course, like there are some hard lines, like the availability of logs for a year, but anyway, that's a larger requirement even for your personal data. So but yeah, otherwise I do read this to be, you do definitely look at nature of business and see what's appropriate in that context.
Understood. One final question on security thing. It's the breach question. Of course, the unlike the GDPR, there's no materiality or risk or harm threshold really baked in over here. Do we actually need to report all breaches? And if so, how might you plan to build in or create a system that enables or meets this high requirement?
Mhm. Yeah, unfortunately, I think there is no risk threshold. So if it is a breach and you designate it as as a breach internally, you've assessed whether there is actual unauthorized access, or disclosure, or all of those breaches of accident, whatever it might be, of personal data, then you have to report to all affected data principals. Um, it and essentially the tiered notification to the board and to the individuals does get triggered. And what all you need to include in the notice as well. I think you could play around with what are the different ways in which you could report, but actually the rules do say that the user account that the individual has created with you, that's the mechanism through which you report to them. So if they've registered using an email ID, then you report using that. If it's some other mechanism, you report using that. But I think it is mandatory now to report all breaches.
Understood, understood. I'm also now mindful of time. I think we're around 7 minutes over. Like to wrap up over here. I know we have a few questions in the chat. What I wanted to say is that with this session, we've of course covered the sort of general overview of what the rules say. We will be following this up with more sector-specific sessions, focusing on fintech, deep diving into edtech, and so on. So all of the questions that you have shared in the chat, perhaps we haven't got the opportunity to get them today, but we'll keep a note of those and we'll try to respond to them definitely as we have some of these future sessions. But yes, on that note, would like to wrap up. But before doing that, maybe I'll hand over back to Sreenidhi or Aman if you had any closing remarks, any thoughts that you wanted to leave our participants.
I will only say there's such fantastic nuanced questions that we've been getting. Like, just keep them coming. I said this last time, I'm going to say it again. Keep the questions coming. It forces us all to think, and we love, getting together as a group and kind of thinking through some of those answers.
Exactly. And I think the recurring theme is that now the framework is in place, the act is there, the rules are out. The real work starts now, translating all of this into practice. And these questions are an important element of that. On that note, I'd like to thank everyone. I'd like to thank Sreenidhi, Aman, for your ideas and insights, and to everyone who attended and the brilliant questions. We'll be back with more seminars. Please keep a lookout. Thank you and have a good Friday.